I'd like to welcome Peter Roos of Multicultural Education Training Advocates, co-director. Peter argued a number of cases before the U.S. Supreme Court on educational rights of language minority children. Peter, we have a number of questions for you today. First of all, I wanted to ask about bilingual programs. We've always had bilingual programs in the country, but what is the evolution of language programming in the U.S.?
Well, you can go back as far as you want. I mean, there obviously, as you indicate, have always been some sort of bilingual programs. I mean, immigrants who came over here in the 1700s, most notably German immigrants, set up programs that were both in German and in English. I like to sort of bring it much more up to date than that. I think it is important to think of the sort of educational programs that we have today, in my view, derive from the civil rights movement that really began to gain steam right after the Second World War. Obviously, Brown versus Board of Education, the desegregation case, was in 1954, and that didn't happen overnight. There were parallel cases brought mostly in the segregation area by Latinos in the Southwest, in Arizona and California and Texas at about the same time, and they really came out of people coming back from the war and saying, why should we be segregated? Why should we be discriminated against? We ought to have equal access to all sorts of educational programming. So that's, to me, the roots of what we're sort of working with today. Where we go from there, from post-Second World War, I think probably the next step is 1964 the 1964 Civil Rights Act is a major landmark. It was indeed passed by Congress just after Kennedy died, pushed through by Johnson, primarily to give the federal government the ability to force southern school districts to desegregate. But it is in fact that same law that prohibits not only racial discrimination, but prohibits national origin discrimination that has served as the basis for the fight for linguistic parity. 68, we got the first Title VII, now I guess it's Title III. That was a bilingual education law, and then the first state laws evolved in the early 70s. Massachusetts had the first mandatory bilingual education law in 1972. California and several other states had non-mandatory but funded programs. And then, of course, sort of modern history kicks off with Lau versus Nichols, which was a case brought under the 1964 Civil Rights Act in 1974. As negative as some people seem to think things are today, it's important to understand that it was a case, it was brought by Chinese-speaking students in the San Francisco schools. This is 1974. Brown had been decided 20 years before, in which the school district didn't do anything for the kids, had no programs. We're not talking bilingual, didn't have ESL, didn't have bilingual, didn't have anything for a very significant Chinese-speaking population. And in fact, they challenged the failure to do anything, and the plaintiffs, these Chinese students, lost in the two lower courts. And the general notion was that the schools don't have to change for these kids. It's the kids who've got to make the changes. And the Supreme Court, in a unanimous decision, said no. That's national origin discrimination to deny kids a linguistically responsive program, and that schools, in fact, do have an affirmative obligation under the civil rights laws to address their needs. Now, we can talk about it a little bit more as we go along, but the court in Lao was not asked to put its imprimatur on any particular program, and it did not do so, so that it did not say that bilingual is required or some other thing is required. But what they were concerned about was putting kids in an all-English program and basically saying, you know, you've got to you've got to make it on your own. And they flatly said, no, there have to be affirmative programs to address that. So that's sort of the, what I would call sort of the middle modern history of, and the roots of what we're now working with.